This is Zach Bailey with the Marc Lopez Law Firm, here to talk today about some of the frequently asked questions we have with expungement law in Indiana.
What is the difference between a seal and expungement?
People get confused on this a lot. Really, there's no difference. What we commonly refer to as a seal is a type of expungement. It's under the same chapter of the expungement law, and it's just what we talk about as seals are cases that didn't end in a conviction. So if you got a diversion, if the case was ultimately dismissed, you're eligible to expunge that record a lot quicker, and we can do that more. Whereas a traditional expungement that we talk about is post-conviction, and you're only eligible to do that with your record once in your lifetime.
When am I eligible for an expungement?
If the case didn't end in conviction, you're eligible a year after the date of arrest. If it did end in a conviction, though, it kind of depends on if it's a felony or a misdemeanor, and if it's a felony, what level felony. So if it's a misdemeanor, the short answer is 5 years from the date of conviction. If it's a level 6 felony, probably going to be 8 years. And if it's a higher level felony, it could be a little bit longer. But just give us a call and we'll figure it out.
Will I have to go to court for this?
Oftentimes we don't have to go to court, especially for lower level cases. Sometimes the judge doesn't even have discretion over those. If you're eligible and you meet all the requirements and it's properly filed, the judge doesn't have any discretion over the expungement, and oftentimes we can avoid a hearing for it.
What about my gun rights?
So this will help in restoring your gun rights, and even part of the language of the expungement states that it makes you a proper person again, and that refers to being able to carry a firearm. If it's a domestic violence crime, though, you're going to have to take a few extra steps, and we can help you through all that in order to restore your gun rights.
What happens when a misdemeanor or Class D level 6 felony is expunged?
When your expungement is granted, notice gets sent to a lot of these different bureaus, the state police, all these people who keep a copy of your record. So the companies that run your background, eventually it will fall off of their record. And so pretty soon after the expungement, it'll stop showing up in any sort of background check. And, we can also make sure we have a way of checking to make sure that all these companies have dropped it off. They periodically update their records, but we want to make sure that they know that your expungement has officially been granted and doesn't show up in any background checks.
What happens when a higher level felony is expunged?
So it's a little bit different for higher level felonies, level 5s and above. For those, it gets marked as expunged. And what that means is instead of not showing up in a background check, it may still show up, but it's going to show up clearly and visibly marked that it has been expunged, which is still a big deal. We'll talk about it here in a little bit. Expunged cases, even if it still shows up, they can't be used against you when talking about employment or housing or anything like that.
Can employers ask about criminal cases that have been expunged?
In most instances, they cannot. And the statute specifically says they can't suspend, expel, refuse to employ, refuse to admit, refuse to grant a new license, or otherwise discriminate against someone based on an arrest record that has been expunged or sealed. Essentially, they're supposed to be treated as if they were never convicted of the offense. There are a few small exceptions, but for most people, it never comes up. If we're talking about a typical job background check, that an expunged case is not allowed to be used against you.
Can my expunged case still be used against me?
Yes. There are a few rare carve-outs for it, but mostly it's if you pick up a new case. The most common example we would see is maybe an OVWI offense, where the second time you pick up a DUI can be a felony. So even if you expunge the first one, they can use it as an enhancement. Even an expunged case can be used as an enhancement. So it doesn't, whereas it does help with employment and housing and all that, it still can be used against you to escalate a new crime. So as long as you're staying out of trouble, mostly the answer is no, it cannot be used against you.
I have been denied employment or housing because of my expunged criminal record.
Give us a call. The expungement statute essentially makes you a protected person. And if you're being discriminated on the basis of an expunged case, that's illegal. So give us a call and we'll figure out how we can help you out.
How do I know if I qualify?
Give us a call. We also have plenty of resources. We've got a few articles that we can send you to figure out if you're an eligible person for an expungement. We even have an expungement quiz that'll help run through the whole process and see if you're eligible. Even if you're not eligible, we'll keep an eye out for the date you are eligible. We'll start preparing an expungement ahead of time. So the date you're eligible, we can file and get your record cleaned up. If you have any questions about expungements or anything else, give us a call, 317-632-3642, and always plead the fifth.